Your Worships, I appear on behalf of Mr. Grant to address you in respect of an application for bail. Mr. Grant pleads not guilty to the offence and will say that he was acting in self-defence. If I might first address the three fears of the prosecution, Your Worships. Firstly, in respect of failing to surrender, this unhappy incident did occur while my client was on bail for an unrelated offence, and he did indeed fail to surrender in August 22. But this was caused by an unintentional admin error on his part, where he put the wrong date in his diary. Such a mistake could happen to anyone. Mr. Grant has learned from this experience to ensure that his diary is now better maintained, and he now double checks all of his diary commitments. Failing to appear is therefore very unlikely to happen again, which was clear to the court when my client was produced, as they released him on unconditional bail. So confident were they that he will attend trial. Your Worships can be reassured by that, I suggest, and be equally confident that if you grant bail today, there is no risk that Mr. Grant will fail to surrender. There's also, of course, the option to impose a curfew, which would provide definitive comfort on Mr. Grant's whereabouts. Secondly, there are no substantial grounds on which to conclude Mr. Grant is likely to commit further offences whilst on bail. The charge on which he appears before you today results from an unfortunate and instinctive reaction in self-defence to an assault by the complainant in this case. There is no getting away from the fact that he does have historic domestic-related convictions, but he has turned his life around since 2016. Mr. Grant does not seek to resile from the mistakes of his past. He pled guilty to those offences at the very first opportunity, and for some 6 years now has been a hard-working, tax-paying member of society with a young child and a managerial career that he has worked hard for and which he is likely to lose should he be remanded in custody. Again, suitable conditions could address any fear you nonetheless may have about granting bail. Lastly, there are no substantial grounds to believe that Mr. Grant would interfere with the complainant in this case. The references made by the prosecution to relevant history are unfair. Mr. Grant did not have the benefit of direction and structure in his younger days. Far more relevant to the matter before you today, and to the man that Mr. Grant is today, are the following factors which I would ask you to consider. He has no recent findings of domestic-related offences. He has no intention of continuing or seeking to continue his relationship with the complainant, and intends to move to live with his mother, some 10 miles from the complainant's home. And his mother is here today, Your Worships, to provide assurance on that. Mr. Grant is in fact willing to undertake not to venture into Liverpool at all. He works full-time, 5 days a week, and at weekends cares for his 4-year-old child. He therefore neither has intention, means, nor opportunity to interfere with the complainant, or indeed to cause her injury or fear of such as an associated person. I invite you to conclude that the prosecution's concern in this regard is not well-founded. Indeed, Your Worships may consider that there is a more fundamental issue with the prosecution's position today. There are no witnesses to this incident other than the complainant who initiated the altercation. The assault is at the lower end of the scale for an offence of this type, and you may conclude in the circumstances that there are insufficient aggravating or culpable features and no real prospect of Mr. Grant being sentenced to a custodial sentence. Given these weaknesses, there is, you may feel, little reason why Mr. Grant would fail to attend for the substantive hearing for fear of being found guilty. That being said, you may nonetheless take the view, Your Worships, that any residual risk could be addressed by granting bail with conditions. I propose the following: a condition not to contact the complainant, not to go to Liverpool, and to live and sleep each night at his mother's address. If Your Worships deem it appropriate, my client is also willing to abide by a curfew. I submit on Mr. Grant's behalf that to remand him into custody would be disproportionate in the circumstances, particularly where he is willing to comply with conditions, and a combination of the conditions such as those I have proposed would address all of the concerns raised by the prosecution and hopefully alleviate any concern that your worships may have, unless I can assist you further.
I appear on behalf of Mr. Grant, who makes an application asserting his right to bail under Section 4 of the Bail Act 1976, page 16 in your bundle. The prosecution raises 4 objections: the 3 paragraph 2.1 exceptions listed on page 21, plus the first paragraph 9 consideration from page 26. Your worships, if you'll turn to page 21, I will begin by working through the paragraph 2.1 exceptions in order. Do you have that? I'm grateful. 2.1a, the defendant would fail to surrender to custody. The Crown points to the one recent failure to attend detailed on page 9 of the bundle, completely ignoring my client's striking reliability in attending the previous 6 convictions listed on pages 10 to 11. This sole failure to attend happened accidentally because Mr. Grant put the wrong date in his diary. It was human error and certainly not the substantial grounds required to make out this exception. Moving down, 2.1b, the defendant would commit an offence while on bail. The prosecution say that this alleged offence was committed while on bail for a drink driving offence. But this objection offends the presumption of innocence, as Mr. Grant has not yet been convicted of this offence and is, in fact, contesting this charge. In order to take this point, therefore, they must then point to his historic convictions. However, firstly, on not one of those previous convictions did he ever breach bail. And secondly, his last conviction was in 2015. Since then, he has risen to become a general manager and now earns £40,000 a year, a sum of which he is, rightly, very proud. He has not committed a single criminal offence since qualification. I submit that Mr. Grant is highly unlikely to commit offences on bail. He has never done it before, and he wants to do everything he can to protect his job. Thus, this exception is also not made out, and we move to 2.1c, the defendant would interfere with the witness. Here, the Crown relies on a previous conviction from 2010, 12 years ago. Now, in this case, basic geography prevents Mr. Grant from witness interference. He is moving in with his mother in Birkenhead. His mother confirms that she is happy to have him and she will personally supervise him whilst he is on bail. Her house is 10 minutes walk from his work and his child is also in Birkenhead. He has no reason whatsoever to go anywhere near Liverpool or the witness, Stephanie Rogers. Your worships, these are the only 3 exceptions to the right to bail, and one of them must apply on the facts for bail to be denied. There are, however, a series of considerations to be weighed in making a decision. These can be found at page 26, paragraph 9. I'll give you a moment to find them. The prosecution would like me to address 9A, the seriousness of the offence. This is not a strong factor in any decision as to whether to refuse bail. Mr. Grant has entered a not guilty plea and has a good defence of self-defence. While the burden of proof lies with the prosecution, as there is no witness to corroborate Ms. Rogers' account, Mr. Grant feels he has a good chance of acquittal. But even if convicted, it is a category 2C offence on the guidelines beginning at page 35 of the bundle, for which the top of the sentencing range is 36 weeks. Whilst his previous convictions are an aggravating factor, he has never been to prison before, has not offended in 7 years, and has a good job and a 4-year-old child, so there would be mitigation. I respectfully submit that he would therefore have a good case for a community order or suspended sentence, and thus the court should not place undue weight on this. Regarding conditions, I have clear instructions from Mr. Grant that he is keen to cooperate with anything, as he always has done in the past. Firstly, while he has significant responsibilities, a steady job from 8 to 4 and weekend childcare, he could report to a police station any weekday after 5 p.m. He is also willing to submit to an exclusionary condition not to enter Liverpool and a residence condition to remain at his mother's house, monitored by location or curfew tags. Finally, he will agree to a condition not to contact the witness, either directly or indirectly. In summary, therefore, I submit that my client should be granted the bail to which he is in principle legally entitled. There simply are not the substantial grounds for believing the 2.1 exceptions to apply, and I have offered the court suitable bail conditions. Unless I can assist you any further, those are my submissions this afternoon. Thank you very much.
My name is Ms. Ibrahim, and I appear on behalf of the defendant, Mr. Grant, to make an application for bail. Mr. Grant is charged with assault occasioning actual bodily harm. Although charges are of a serious nature, it is important to acknowledge that this was an act of self-defense, and whilst there was a broken nose sustained by Ms. Rogers, there was no other harm. The prosecution has submitted that bail should not be granted. However, it is submitted here that there are no substantial grounds for believing that Mr. Grant, if released on conditional bail, would meet any of the 3 exceptions for bail. Your worships, these exceptions can be found on page 21 of the bundle. And the following bail conditions are proposed today. Firstly, a curfew at Mr. Grant's mother's address between 7 p.m. and 7 a.m. And secondly, a condition not to enter Liverpool, save for court hearings. I will structure my submissions by referring to the 3 exceptions to bail and make 3 submissions today. Firstly, if Mr. Grant is given conditional bail, he would be likely to surrender. Secondly, that Mr. Grant would not commit any further offences whilst on conditional bail. And thirdly, that Mr. Grant would not interfere with the witness on conditional bail. If it pleases your worships, I will now take each submission in turn. I begin by submitting that there are no substantial grounds for believing that Mr. Grant on conditional bail would be unlikely to surrender. Mr. Grant has never breached bail in the past, and he was also granted unconditional bail at his previous hearing. It is acknowledged that Mr. Grant did miss a court hearing this summer on the 12th of August 2022. However, this was an accident, as regrettably, Mr. Grant put the wrong date in his diary. What is important here, however, is that this was a one-off occurrence, and instead there is a pattern of Mr. Grant adhering to bail. Further, Mr. Grant is very willing and motivated to comply with bail conditions for 2 reasons. Firstly, Mr. Grant looks after his 4-year-old child, and if remanded, this will cause difficulties as to childcare. Secondly, if remanded, it is likely that Mr. Grant will lose his job that he has worked very hard to get. Overall, there are therefore no substantial grounds for believing that Mr. Grant on conditional bail would be unlikely to surrender. I now turn to the second submission, that Mr. Grant would not commit further offences on conditional bail. It is conceded that Mr. Grant does have a history of convictions. However, your worships, context is important. Mr. Grant had a difficult childhood, but has managed to turn his life around. In 2016, he obtained a forklift truck licence and is now a manager at a warehouse. Since doing this in 2016, he has not committed any further criminal offences. His last conviction was in 2015, 7 years ago. Further, Mr. Grant's mother is willing to be vigilant and support Mr. Grant to not commit further offences. Overall, there are therefore no substantial grounds for believing that further offences will be committed by Mr. Grant on conditional bail. Rather, if bail is refused, Mr. Grant will likely lose the job that has helped him turn his life around. I now turn to my final point, that there are no substantial grounds for believing that Mr. Grant would interfere with Miss Rogers on conditional bail. Mr. Grant and Miss Rogers had a short relationship of 6 months. Mr. Grant accepts that the relationship is over and intends to move out and live with his mother outside of Liverpool. It is acknowledged again that Mr. Grant does have a history of convictions in domestic setting. But your worships, context is important here again. The harassment charge occurred in 2013, before Mr. Grant changed his life around, and whilst he was under the influence of a significant amount of alcohol. Mr. Grant severely regretted doing this, made a full admission at interview, and pleaded guilty at first appearance. In addition, the witness intimidation occurred in 2010 on a regrettable impulse when Mr. Grant ran into his then-girlfriend by mere chance in the street. However, in this case, Mr. Grant will be living at his mother's home, 10 miles away from Miss Rogers. Mr. Grant has no ties to Liverpool. His friends, family, child and work are all based in Birkenhead. So he has no reason to return to Liverpool, and neither does he have a car. So it will be difficult for him to get there and either intentionally or coincidentally run into Miss Rogers. As such, when considering these factors, there are no substantial grounds for believing that Mr. Grant would interfere with Ms. Rogers on conditional bail. To summarise, Your Worships, it is submitted that there are no substantial grounds for believing that Mr. Grant would meet any of the 3 exceptions to right to bail if released on conditional bail. Unless I may assist further, I rest my submissions here.
Good afternoon, Your Worships. My name is RAVINA BAHRA, and I appear before you on behalf of the defendant, Mr. David Grant, to make an application for bail. Your Worships, I have a lingering cough, so please do excuse me if this happens to interrupt my submissions. Do you all have a copy of the bundle?
We do.
May I dispose of running through the facts of the case?
Please do.
Might I remind you that there is a presumption in favour of bail as created by the Bail Act 1976, which is page 16 of the bundle. There are 3 grounds raised by the prosecution in opposition of granting bail. These are that if released on bail, the defendant would be likely to fail to surrender to custody. He would be likely to commit further offences, and he would be likely to interfere with the witness. I will address each of these grounds in turn. The prosecution submits that the defendant would be unlikely to surrender as he didn't attend a first appearance for a previous offence. The defendant has explained that he failed to attend as he accidentally put the wrong date in his diary. I submit that the defendant has strong community ties, making it unlikely that he would abscond. Since 2016, he has had stable employment that he has worked very hard to obtain. He worked his way up over the past 6 years, and he now holds a managerial position. If he is held in remand, there is a strong likelihood that he will lose his job, and it is likely that it will be difficult for him to secure a similar one. His risk of absconding is low, as he would not risk jeopardising his career. The defendant also has strong family ties that prevent him from absconding. He proposes to live with his mother, and he has a 4-year-old child who he looks after on weekends. To mitigate the possibility of the defendant failing to surrender to custody, I submit that the court grant bail accompanied by a condition of residence, so that he will live and sleep at his mother's address, and that he regularly reports to a local police station. The prosecution submits that the defendant would be likely to commit further offences, as he has previous convictions for domestic-related assaults. His last conviction for assault was 7 years ago, and the other 12 years ago. I submit that these offences took place long enough ago that they do not increase the seriousness of this offence, and alone are not a conclusive reason for refusing bail. The defendant has not been charged with another offence since entering his current employment. The previous similar offences were committed either under the influence of alcohol or in a pub setting. So to mitigate the possibility of a reoffence, I submit that bail be granted with the condition of a curfew and an electronic tag, which keeps him at his mother's address between the hours of 7 p.m. and 7 a.m. The prosecution submits that the defendant would be likely to interfere with a witness, as he has previous convictions for witness intimidation and harassment. I submit that lesser importance be placed on these convictions at this point in proceedings, as they are 9 and 12 years old. The defendant proposes to live with his mother in Birkenhead, which is 10 miles from the complainant's home. His friends, his family, his child, and his job are all based in Birkenhead, so he has no ties to Liverpool, which is where the complainant lives. He also doesn't have a car. To mitigate the possibility of witness interference, I submit that bail be granted with a condition that he does not enter Liverpool, save for court hearings, and that he does not contact the complainant, either indirectly or directly. Your Worships, as these conditions will strongly reduce the possibility of him partaking in the conduct proposed by the prosecution, I respectfully ask that the court grants bail for the defendant. Unless I can assist you any further, I hereby conclude my submissions.
May it please the court, my name is Miss Peel and I appear on behalf of the defendant, Mr. David Grant, in his application this afternoon. Mr. Grant has been charged with assault occasioning actual bodily harm contrary to section 47 of the Offences Against the Person Act, 1861. It is important to acknowledge from the outset, Your Worships, that the offence is vehemently denied by Mr. Grant and will proceed to a full trial. Your Worships will have heard a summary of the facts from the prosecution, and you will have also heard the grounds upon which they intend to rely to oppose his bail application. As the court will know, the presumption of bail is in Mr. Grant's favour, and the prosecution must prove that there are substantial grounds for believing that the objections are made out. I will take each ground in turn, addressing why such a threshold has not been met. Turning first to the prosecution's concern that Mr. Grant is likely to commit further offences whilst on bail. Your Worships, may I submit the following? You will have had a view of Mr. Grant's antecedent history. The previous domestic-related assault convictions, which the prosecution seeks to rely upon, are simply dated and spent, the most recent having occurred 7 years ago. Mr. Grant does not and cannot contest these convictions, but rather shows regrets and remorse, having pleaded guilty and having accepted and complied with the sentence handed down. Your Worships, Mr. Grant acknowledges that he has a troubled past. However, he has worked hard to rehabilitate himself and turn his life around. I draw the court's particular attention to the fact that Mr. Grant had gone on to obtain a professional qualification in 2016 and now holds a respectable job within the community. He works the hours of 8 AM to 4 PM, Monday to Friday. Mr. Grant also has a young son whom he cares for over the weekend whilst the child's mother is at work. In a nutshell, Your Worships, the life that Mr. Grant has worked hard to build may well be jeopardised if he is remanded into custody. He will be at risk of losing his job and causing unnecessary rifts in those important relationships. My third submission on that point is that should the court continue to be concerned, perhaps imposing a curfew condition on Mr. Grant's bail may well be appropriate between the hours of 7 PM and 7 AM whilst he is not at work. Turning to the prosecution's second ground, in that the defendant is likely to fail to surrender. Your Worships, I have 3 submissions to make on this point. Firstly, the previous instance of failing to surrender has been acknowledged by Mr. Grant, but he maintains that this was entirely accidental due to a misunderstanding of the relevant previous court dates. He submits that he has reasonable cause. Notwithstanding, one previous instance of failing to surrender does not, in my respectful submission, demonstrate a propensity to abscond. Secondly, it is also not in Mr. Grant's interest to abscond, of which he is well aware. I have already alluded to the fact that he has stable employment which he is at risk of losing, and he has commitments to a young child. Mr. Grant is also aware that he would risk a much higher sentence should he fail to abscond due to the fairly low severity of the particular circumstances of the offence. Your Worships, Mr. Grant also has a stable address. He is moving into his mother's residence, the details of which I will come on to. His mother is committed to ensuring that his life stays on track. If the court is still concerned, then perhaps imposing a bail condition whereby his mother acts as a surety for his return to court may well be appropriate. Turning now to the prosecution's allegation that the defendant is likely to interfere with witnesses. The prosecution has adduced little evidence of this, and on this I submit the following. Firstly, the previous conviction for witness intimidation dates back to 2010, some 12 years ago. I've already alluded to how Mr. Grant has turned his life around, and he is specifically taking steps to alleviate the court's concerns, which brings me on to my second submission. The relationship with the complainant is now over. He has moved out of the property into his mother's residence in Birkenhead, some 10 miles away from the complainant's home in Liverpool. He now has no ties to Liverpool and no reason to enter. Once again, should the court consider it necessary as an alternative to unconditional bail, perhaps an exclusion condition could be imposed on Mr. Grant's bail, prohibiting him from entering Liverpool. Your Worships, I have outlined each of the prosecution's ground for opposing bails in today's application and have set out why they do not have substantial grounds for believing that each objection has been met. Unless I can assist the court any further, that concludes my submissions for this afternoon.